Jim Duff, the Executive Director of the Supreme Court Historical Society, and I'm delighted to welcome you today to our virtual platform for today's Constitution Day program with former Solicitor General Noel Francisco. Noel John Francisco was sworn in, I should say, as the 47th Solicitor General of the United States on September 19th, 2017, 2 days after Constitution Day. He was raised in Oswego, New York, and received his BA with honors in 1991 from the University of Chicago, and a JD with high honors in 1996 from the University of Chicago Law School. After law school, Mr. Francisco served as law clerk to Judge Michael Ludig of the United States Court of Appeals for the Fourth Circuit, before clerking for Justice Antonin Scalia at the Supreme Court. From 2001 to 2003, Noel served in the office of counsel to the president as associate counsel to President George W. Bush. And from 2003 to 2005, he served as Deputy Assistant Attorney General in the United States Department of Justice Office of Legal Counsel. He was a partner at the law firm of Jones Day prior to his service as Solicitor General, and he is currently the partner in charge of their Washington, D.C. office. You've had some nice titles in your career. I think partner in charge is a good one. He's also a trustee of the Supreme Court Historical Society, for which we're very grateful. We appreciate his contributions over the years and his contributions to our country, especially as we honor our Constitution on Constitution Day. We're going to take questions from the audience at the end of our discussion, so please share your questions in the Q&A box at the bottom of your Zoom screen. And I'll begin, Noel, with just asking some general questions about your career path decisions and what influenced them, and how did you land in the SG's office?
Sure. Thanks, Jim. And it's really great to be here with you all on Constitution Day, and great to be doing this with the Historical Society. Back when I was in law school, I was pretty convinced that I just wanted to stay in Chicago and become a trial lawyer. I was really attracted to products liability law. I thought I'd join up with a big firm in Chicago and be a products liability defense lawyer. But through a mutual friend, I ended up landing a clerkship with Judge Ludig, who was then based in Northern Virginia, right outside of Washington, D.C. And back then, Ludig had only been on the bench for 3 years, so he wasn't as well known as he ultimately came to be. But he was Justice Scalia's very first law clerk when Justice Scalia was on the D.C. Circuit. And as a result, back then, Scalia would always hire one Ludig clerk. Well, when I arrived in Ludig's chambers, my other two co-clerks had already secured clerkships with Justices Thomas and O'Connor. So Scalia had no choice but to take me. And that's how I landed the Scalia clerkship. All of that's a long-winded way of saying that even though I still at that point intended on going back to Chicago, it was the influences of Judge Ludig and then Justice Scalia, and then ultimately the partners that I worked for at a small law firm called Cooper, Carvin, and Rosenthal, Chuck Cooper and Mike Carvin, that convinced me that it really made more sense for my career to stay in D.C. Looking back, I questioned that. I think I would have been very happy in Chicago, but that's what landed me in D.C., and that's, I think, eventually what led me into several stints in government service, the latest being as Solicitor General.
That's great. It's a great career path, and we're glad you took it. And full disclosure, I met Mike Ludig in Chief Justice Berger's chambers. We both worked for Chief Justice Berger back in the late 1970s. So
I've heard many stories from those days.
We've got a lot of background in common. You served as a Solicitor General for 4 years, and how has it shaped your career since then? And I assume you decided not to go back to Chicago in the aftermath of serving as SG.
So, when I decided to stay in Washington, I started out with that small law firm, Cooper, Carvin and Rosenthal, into the Bush administration, then after that to Jones Day. And one thing that emerged during all that time in the cases that I was handling was that I tended to have either the federal government or the state government on the other side of the case. So we tended to be representing clients that were suing the federal or state governments or that were defending against enforcement actions brought by federal and state governments. And that tends to raise a lot of constitutional issues and it's structural constitutional issues. And I think that that was the background I had when I went into the Solicitor General's office. And I think it's what made me reasonably well prepared to handle the types of cases that we handle in the SG's office. Coming back out to Jones Day, sort of the latest stage of my career, what I found is that I still get a lot of cases that are in that ilk. But more generally, I think the biggest difference is I handle a lot more cases, but I do it with a lot more lawyers assisting me. So I tend to be involved in a very large number of cases. I keep on top of the cases to make sure they're moving, but I don't take as deep a dive into each case until particular periods of time. And that's a big shift from my career previously, where I handled a smaller number of cases, but was largely the principal lawyer or the only lawyer handling them. The second time, I find myself working with much greater teams of lawyers. And that's why I feel that I'm lucky to be where I'm at right now at Jones Day, because we really do just have a wonderful team of lawyers to work on these matters.
Well, that's great. Do you miss government service at all?
Yes and no. It's very exciting. You're in the middle of a lot of big issues. But I tell you, at every stage in my career where I've been in the government and then was looking at heading out into private practice, starting with when I clerked, then when I was in the Bush administration, then when I was in the Solicitor General's office, I always thought, all right, I've been doing all of these exciting things in government. Now I'm going to go back out into private practice, and it's not going to be nearly as exciting. And every time I've been wrong. I actually find the cases that we handle in private practice every bit as interesting as the ones I was handling in the government. Dispositionally, I think I'm better suited to be litigating against the government than to be defending the government. That tends to more align, with my views and my interests. So I really enjoy being in private practice.
Well, that's good. Any thoughts about future service in government, or are those days pretty much behind?
I'm starting to get longer in the tooth. There are fewer things that would make sense, but I'm always open to public service. It's a great calling.
Yeah. Well, I think I'm like you. I've been in and out of the private and public sectors, and I do find the rewards in the public sector are so great, and not necessarily monetarily, but working for the country. I think is something that it's hard to duplicate in the private sector. And not to say the causes aren't similar or aren't good for the country, but representing the United States is quite an honor, as you well know. And so let's talk about the role and structure of the office of the Solicitor General. It was created back in 1870. Do we know why in that particular time it came in?
I can't. I don't know for sure. I'm sure there's somebody that does. My understanding is that up until that time, or for most of the period before that time, there really wasn't a Department of Justice. You had the Attorney General. Yeah. And the Attorney General was, a guy who was, both advised the president and probably had his own private practice and worked with other lawyers who was able to assist him. I think that in 1870, that's when they formally created the Department of Justice. Yeah. And created, that in the original act in 1870, I think that there were only two officials that were listed within that act. There was the Attorney General and there was the Solicitor General. And really, everybody else that came to populate the Department of Justice over the years were just different lawyers that came in to assist one of those two officials. And over time, the structure expanded and it became much more formalized. But I think at the time, that was when they were first just creating a formal department.
Well, it's very interesting, Noel. I think in the history of the three branches of government, and we're going to talk about the overlap between the SG's office and the judicial branch in a moment. But in those days, and the 1870s and up until 1920s, the Department of Justice actually represented the judicial branch and its administration before Congress. There was no independent administrative arm of the judicial branch from the inception of the country up until the 1920s, when the Judicial Conference was created, and then the administrative office of the U.S. Court. So everything was still evolving in those days as to how the court system worked, or the Department of Justice's interaction with it, which leads to the question about the interaction. The Solicitor General is in the Department of Justice, the executive branch, as you point out. It's sometimes referred to as the 10th Justice. That is, the Solicitor General is referred to as the 10th Justice. Yet it is an office within the executive branch at the DOJ. And so how does that work exactly? And what does the office do?
So Jim, the first thing I'll say is that I don't believe I've ever heard a Supreme Court justice refer to the Solicitor General as the 10th Justice.
Promise.
Yeah, and I think that that term is true in a small sense and not really true in a big sense. In a small sense, it's true because the Solicitor General is a repeat player, somebody who is appearing before the Supreme Court year after year in a range of cases. And so it's important that, and always defending the same client instead of clients, the executive branch. And so it's important that there be a certain consistency, because you don't want to win a case on Monday that causes you to lose the cases that you're arguing on Tuesday and Wednesday. And because you're a repeat player, there's a certain amount of credibility that comes with the office that every Solicitor General is charged with preserving. So I think in that sense, that's maybe what people mean when they talk about the Solicitor General being the 10th Justice. But in a much larger sense, you are a lawyer representing a client. I never viewed the role of Solicitor General as trying to explain to the court what the theoretically right, platonically pure answer was under the law. Rather, my job was to advance arguments that would advance the interests of the government. You make reasonable arguments in defense of federal statutes. You make reasonable arguments in defense of regulations. You make reasonable arguments in defense of executive orders. At the end of the day, you're a lawyer that's trying to win cases on behalf of your client within the bounds of reason. You're not making any argument under the sun. You're trying to advance the overall interests of the government. Now, in terms of how the office is structured, it's a very small office. There are only I guess about 20 lawyers in the office. You have the Solicitor General, anywhere between 3 and 5 deputies, depending on the time, and about 16 assistants to the Solicitor General. And that group of lawyers argues every case before the United States Supreme Court on behalf of the government. That being said, the office is assisted not only by the Department of Justice as a whole, but by lawyers throughout the executive branch and all of the different agencies. So when we were arguing cases on behalf of, say, the Environmental Protection Agency to defend an EPA regulation, we were working with EPA lawyers. We were working with the lawyers in the Environmental and Natural Resources Division within the Department of Justice, within sometimes the U.S. Attorney's offices, as well as the deputies and assistants in the Solicitor General's office. So it really is, on a lot of these big cases, it really is a whole of government effort.
It's an enormous responsibility that the office has, and an enormously broad task. There are 2,000 agencies in the United States government, and does the SG's office represent all of those agencies and even the so-called independent agencies such as the CIA, the Federal
Uh,
Reserve?
I am pretty sure that the Solicitor General represents all of the agencies in the Supreme Court. Now, there might be one or two exceptions to that.
Mhm.
Generally, the Department of Justice represents the executive branch when they're litigating in court. There are a handful of independent agencies that have independent litigating authority in the lower courts. So, for example, I think the FTC can bring their own enforcement actions in federal court. But for the most part, even with respect to those independent agencies, if a case gets to the Supreme Court, then it's the Solicitor General's office that handles that case.
Okay. That's interesting. And how do you, with all those differing agencies and their interests, their independent interests, sometimes it would be inevitable, it seems to me, that sometimes those interests might conflict. That is, you have uh, two separate agencies with competing interests in the courts, and maybe competing interests even as to whether to take an appeal to the Supreme Court or petition for the court's review. So, how do you go about balancing those competing interests? Well, first of all, are there such situations where
That
there's,
yes, there are some. There are more situations where a lot of agencies have a competing interest. They don't necessarily conflict. They're just not perfectly aligned, and you need to come up with a solution that pretty much advances everybody's objective to the best that you can. So more in the way of not is it do we go left or right, but is it how do we put together a position that best advances everyone's interests collectively. There are a handful of cases where where two agencies just have diametrically opposite views. I actually only recall one case during my time where we had an issue, and if we argued it one way, it helped one agency and hurt the other, and vice versa. And we really did have to make a decision between the two agencies. There was no choice but to do it. But in all of these situations, whether they're diametrically opposed or whether you're just balancing the interests, what happens is that the office will convene a meeting with all of the interested parties. And sometimes you'll get into a big conference room with around 20, 25 different lawyers representing all the different agencies. And you really do give everybody a chance to make their case and say their piece. They'll do it both in the form of written memoranda, but then they'll come to the meeting and we'll really hash it out. And at that point, you always have to have a decision maker. And at that point, it's ultimately the Solicitor General that's the decision maker in those cases. Obviously, the Solicitor General is consulting with all kinds of people, both up the chain and down the chain. But the SG makes the call. I think that folks are pretty good at understanding what the interests of the different agencies are, and we always did our very best to try to advance a position that was that was most aligned with most of the agency's views.
what does when the SGA makes the call, and you go with one agency's interest over another, does for lack of a better description, does the losing agency in that decision have any other recourse, or is it they just have to, in essence, fall in line with this is what the government's position is going to be?
Yeah, I mean, I guess they could attempt to get the Solicitor General overruled, and you could maybe go to the Attorney General or even the President. I
Yeah,
tell you though, if you're doing your job right as a Solicitor General,
yeah,
nobody's going to be surprised at the decision. So while it's ultimately, I mean, my general approach to the job was, well, I felt that, there were certain things that were within my decision-making bailiwick.
yeah,
If it were going to be controversial, I made sure, for example, that the Attorney General knew about the issue and where I was going, so
mhm,
that if he had a viewpoint on it, he had an opportunity to express that viewpoint. So if you're doing the job right, well, theoretically, there's the ability to have the Solicitor General overruled by those higher up the chain. It's not likely to be successful because you will all have already socialized the
yeah.
issue with all of the relevant decision makers.
Yeah, yeah, that's good. That's a good description. Uh, how many the Supreme Court's typical term these days? I guess it's a fewer cases today than there were when you clerked for Justice Scalia, but I don't know what there were those days. And the Ludig day, when we were in the Berger chambers, there were 150, 160 cases per term. Now it's maybe 70 or 60. How many of those cases would the SG
Yeah.
participate in generally?
So the office generally participates in about three-quarters of the cases that the Supreme Court hears. And within that three-quarters, about half of them, the government will actually be a party to the case. And in the other half, the government would be an amicus in the case. But so say if they hear 70 cases, I imagine in the SG's office is in roughly 50 of those cases. It's interesting the shrinking of the docket in terms of argued cases actually does impact the office a bit. One of the reasons, one of the ways that we're able to attract such high quality young talent into the Solicitor General's office is because one of the things that we would offer is the opportunity to argue cases before the U.S. Supreme Court at a relatively young age. Um, there are a few cases when the court takes fewer cases, there are fewer argued cases. There are fewer cases to share amongst the assistants. So whereas assistants previously might have gotten two, three, maybe even four arguments a term, I think now it's probably more like one or two and maybe three for the most senior people. One of the things I confronted when I was there, and I think every Solicitor General probably confronts this, is that all of the assistants to the Attorney General always come forward and say they would like to argue a case.
Yeah.
So, the head of the environmental division wants to argue an environmental case. The head of the criminal division wants to argue a criminal case. And it's quite difficult to accommodate all those requests while at the same time making sure that you have enough arguments to keep all of the assistants in the Solicitor General's office happy and busy.
But how many cases did you usually take, Noel, when you were SG?
So I would typically argue one case each sitting.
Okay.
Occasionally two, if there were two that required Solicitor General participation, but usually one.
Yeah. And there are those who stay in the SG's office from year to year over the years. So many are there for long periods of their career. I assume. I don't know what the percentages are. Maybe you have a sense of that.
So I think amongst the assistants, you
Yeah.
typically expect that the assistants will stay roughly 5 years. Some stay more, some stay less, but I think that's probably a pretty good average. Now, the deputies, and particularly the career deputies, tend to have been there for a very long time. We just celebrated the retirement of Ed Needler the other night. We had a dinner for him, and gosh, do you know how many years Ed was there?
Oh,
It was like 40 years.
yeah, I think it was over 40. Yeah.
Over 40 years. I mean, you would look at the pictures on the wall of all of the past SG's offices, and there was Ed Needler standing next to Robert Bork. There was Ed Needler. You just go through all of the Solicitor Generals throughout history, and Ed standing next to them wearing his signature beard. So amongst the deputies, you have much greater longevity in that office.
Yeah. And do those who stay for longer periods of their career, do they develop a particular expertise, or how do you decide? And is it the SG's decision who gets to argue which cases, and how do you allocate those? And or do they, somebody like Ed, would he express a particular desire to argue a particular case, but given his background, and do you defer to those
Right.
that are longer?
So the assistants are expected to be able to handle anything. Because of the number of cases in the office, they need to be able to handle anything that comes in the door. I think some of them do develop areas of specialty, maybe in the criminal area. I recall we had a guy that was an expert in FOIA. And so they would handle the big criminal or the big FOIA cases, but really others would also handle criminal and FOIA cases, and they'd all be expected to handle what comes in the door. Amongst the deputies, they did develop areas of specialty and would sort of divide up the docket. There's always been a criminal deputy, and so that deputy handles all of the criminal cases. For a long time, it was Michael Dreeben. Now it's Eric Fagan. Uh, Malcolm Stewart is the deputy who handles what we would often refer to as the business docket. You know, they were the SEC cases, the antitrust cases, the intellectual property cases. I think Malcolm could probably make a lot of money if he ever decided to leave the government and go into private practice. Ed Needler handled all of the immigration cases, all of the Indian law cases, and a whole bunch of other things as well. And then the political deputy would typically just divide up with the Solicitor General, you know, a lot of the sort of hot button cases that are of particular importance to the administration.
Yeah. Does everyone get a chance to argue at the court if who's in the SG's office or?
Yes, every assistant and deputy argues cases each term. The goal is to make sure each assistant has at least one argument a term.
Yeah. What a great experience and exposure. And it is easy to see why you attract such high quality people to that office. What role does the SG's office play in the lower federal court cases, if any?
Sure. Oh, and there was one other part of your question that I didn't get to. You asked who assigns the arguments.
Yeah.
It technically is the Solicitor General. But what would happen is I would get a list of recommendations from the deputies, and typically you just sort of sign off on the list. In terms of what cases the Solicitor General, him or herself, argues, in theory, the SG has total discretion to argue whatever case he or she wants. In fact, there's virtually no discretion at all. In any given sitting, it's going to be obvious that there were one or two cases that are of such importance that the Solicitor General would be expected to argue it. You know, for example, when President Trump, during his first term, issued the travel ban executive order, I couldn't exactly send an assistant up to defend the executive order. That's something where it's expected that the Solicitor General would himself argue it. And there's almost always a case like that each sitting. So, well, in theory, you have lots of discretion. In fact, you have very little discretion in terms of that.
And then does the Supreme Court ever call upon the SG's office for its views in a case, even when the U.S. isn't a party to the case?
Yeah, Jim, you probably remember this back when you were working for Chief Justice Rehnquist, but there is a process called dubbed Call for the Views of the Solicitor General, CVSG, where the Supreme Court asks the Solicitor General to opine on whether or not it should grant a case. And I believe that Chief Justice Rehnquist used to refer to that process as calling for the views of another law clerk, which is a good juxtaposition to the notion that the Solicitor General is the 10th Justice.
Yeah, I think I've heard that phrase before. And how often does that happen? Is it rare? Would you say?
No, it's not rare. It probably happens 5 to 10 times a year,
Okay.
I'd say. Yeah.
Does the SG's office always appeal a loss in the lower courts, or is there some discretion there?
Yeah, it definitely does not always appeal a loss in the lower courts. And, you know, whenever the way the process works is that whenever the government loses in the lower courts and wants to take an appeal, so if it loses in the district court and wants to appeal the Court of Appeals, or it loses in the Court of Appeals and wants to take it up to the Supreme Court, that decision also always has to be approved by the Solicitor General. And that's essentially how the department tries to maintain a consistent litigating position across the country by making sure that whenever the government is the appellant, the Solicitor General's office approves it to ensure that the positions taken are positions that advance the government's interests overall, and that the government isn't taking inconsistent positions across the country. In deciding whether or not to appeal, a lot of things go into making that decision, but sometimes the government is just advanced an erroneous argument and it shouldn't have won. Sometimes you actually think you're right. You think that the lower court ought to go your way, but there's a real serious risk that they're not going to go your way. And so there's a risk of turning a loss in the district court into a loss in the circuit court, which has a lot bigger impact, or a loss in the circuit court into a loss in the Supreme Court, which then has a nationwide impact. So often you'll look at cases and say, look, this is not the case we want to take up on appeal. If we're going to bring this issue up to, for example, the Supreme Court, we want to wait till we get a better set of facts or a better record so we have a better chance of prevailing once we get up to the Supreme Court.
There was a lot of consideration given to the environment at the time and the courts. With a party occupying the White House, James, how does that affect the SG's work, if at all?
Yeah, well, it certainly affects it, but probably less than people might think. The vast majority of cases that are being handled in the lower courts and in the Supreme Court on behalf of the government, the interests of the government are going to be the same no matter who's in power. Generally, we're defending criminal. If we obtain a criminal conviction, we're going to try to defend that conviction in the appellate courts. Generally, if an agency promulgates a rule or a regulation, we're going to defend that rule or regulation. Now, a lot of times when administrations change, there'll be a call for, some particular regulation is being defended in court from the prior administration, and some might say, well, you should stop defending that regulation. Usually what the response is that that's actually not a very good idea, because the arguments that we're making in defense of that regulation are the same arguments we're going to be making in defense of the regulations that the current administration wants to put out. Instead, usually the proper response is to change the regulation. So if you withdraw the regulation or you amend it, then we can go into court and say the case is moot. The regulation has been changed, it's been withdrawn, so you shouldn't continue on with the lawsuit. So most of the time, the litigating positions aren't affected by changes in administration. Now, there are certainly a handful of exceptions to that. I think every Solicitor General confronts a handful of cases when they've got to decide whether or not to maintain the litigating position of their predecessor. I usually applied what I call a three-factor test when an issue like that landed on my desk. I'd ask, is the issue important? Are we right? And are we going to win? And if it satisfied all three of those factors, then I thought it was a reasonable candidate for a reversal of position. But even if it was important, and even if I thought we were right, if I didn't think we were going to win, I would often say, it's not really worth the political capital we're going to have to expend to reverse positions if we're not even going to win on the issue. And I think applying that during my time, we reversed positions maybe 4 times. I think we won all 4 of those cases, so my factors worked out well. But there are occasions where you are called on to change positions. I think where there's the most discretion in the Solicitor General, though, are in cases where the government appears as an amicus. Because when the government appears as an amicus, they really have discretion to side with one party or the other. There's not a formal governmental interest that you're defending. So if you think of a lot of the hot button social issues that arise out of state court litigation, where the United States participates in the case at the Supreme Court level, not as a party, but as an amicus. If you look at those cases, it's probably true that no matter who the president was, they would have filed an amicus brief in that case, given the importance of the case. But which side of that issue they take is very different depending on who the president is. So that's I think the area where who is occupying the White House may have the biggest impact on what positions the Solicitor General's office takes.
And do you ever consult with the prior previous SGs and decisions? I mean, you had a very interesting, good formula, it seems, but
Yeah.
is there consultation that goes on between administrations as well?
Yes, not so much on specific cases. I think that for confidentiality reasons, it would be very difficult to consult on a specific case.
Yeah.
But we have a very close knit network of former SGs. We get together all the time, and I definitely met with every one of them before I took the job just to get the benefit of any advice they had to offer. I had to say, I thought that Don Verrilli, who's become a dear friend of mine, was one of the best consigliaries I could have had before going into that position, to really helping me understand what the role of the office was, where issues were going to arise, and at least one way to go about thinking about them.
No, it's just interesting. How did you prepare for oral argument, Noel, and at the court and in the SG's office, and do you use the same preparation techniques today in your appellate practice?
Yeah, no, I've always had a fairly consistent preparation technique. I start out just by trying to read everything so I get it somewhere in my head. Then I'll sit out, with just a piece of paper and just write out. If I just had 10 minutes to stand up there and articulate what the key points of my case are, what would they be? And those tend to be, the sort of key points that you're trying to make in an argument. And then I try to write out every question I think I might get and every answer that I think I might give to that question. And then the critical part is I actually practice the questions and answers out loud. So I'll often go sit out on a park bench somewhere or sit out in my car with the top down and a cigar, and I'll just start asking myself the questions out loud and answering them out loud, because to a certain extent, oral advocacy is like being an actor that is remembering your lines. You need to recite the lines because sometimes a great idea in your head doesn't naturally roll off your tongue. It takes practice in order to get the answer to roll off your tongue in a way that makes sense, particularly when you're in the midst of a heated oral argument.
Yeah. What kind of cigars do you like?
I've got a whole range of them. Lately, Padrones have been my favorite.
Oh, yeah, there you go. Does the quality of cigar affect the quality of your preparation?
No.
So, and when you're arguing before the court, do you approach the arguments the same way if it's a constitutional question or if it's a statutory one, or there are different methods of preparation depending on the issue?
Yeah, I really don't change my preparation. It's the same for every issue. And I often get asked, do you shape your arguments for the particular justices? And by and large, I don't really do that either, because I'm a big believer in that if you've got a good argument, it's going to be the best argument that you can make no matter what judge you're before. So if you've got a really good textual argument, that textual argument is going to be persuasive to most jurists, whether they consider themselves textualists or not. Nobody really ignores the text. If you don't have a good textual argument, but you've got a good argument based on logic and policy, well, then you've got to go with that. But good arguments are going to be good for the vast majority of jurists, and bad arguments are going to be bad for the vast majority of jurists. So I tend not to try to figure out, all right, what specific argument is going to appeal to what specific judge.
Well, was there anyone you sort of modeled yourself after when it came to oral arguments, that when you were a clerk at the court, were you impressed particularly with anyone that maybe influenced the way you approached arguments going forward?
So I remember one day when I was, I can't remember if I was a young law clerk or I had just started out as an associate and was attending an oral argument, but it was a day where the four advocates were John Roberts, Seth Waxman, Mike Carvin, and Ted Olson.
The-
And so you got to see four of the best advocates of their generation and arguably ever back to back to back to back. And the thing that came across from all four of them is that oral argument just seemed like a conversation. It just seemed like a couple of people who knew each other well and were friends, not a couple, but a group of people who knew each other well and had a lot of history together, just trying to hash out an issue to figure out what the right answer is. And that to me has always been the model for a good argument. It should sound like you're having a conversation with the justices.
Yeah. And is that the advice you give to your to the associates who come through Judge Day? Or
Absolutely. And when they ask me, what are types of things that they should do to learn to become a better advocate, I always say you should learn to have conversations on difficult issues with your friends. Back at the University of Chicago, the law school lounge was called the Green Lounge. And we would often sit around the Green Lounge and we would debate whatever the issues of the day were in the Green Lounge. And I always think back to that and think that a really good oral argument sounds like one of those round table discussions we were having sitting around in the Green Lounge in law school. And if you don't get used to having that type of conversation, even on the most difficult issues, even with people who you very much disagree with, if you don't get used to having those kinds of conversations, you're going to have a much harder time standing up in court and presenting argument on equally difficult and equally controversial issues.
gosh, it's such good advice, Noel, not only for preparation for arguments before the courts, but just generally in society today, how much needed it is to be able to have civilized discourse and exchange of ideas without anger, and learning to do that. It's a very important part. I think the law schools really need to encourage more of that sort of opportunity and atmosphere. I know some law schools have almost formalized that what you described at University of Chicago is kind of an informal practice, but
Yeah, I absolutely agree. And I often say that when I get ready for an argument, and I start trying to understand what the other side's case is, I always start with the presumption that they believe in their case just as much as I believe in my case. They're not there for some narrow parochial interest. They're there because they believe in what they're advocating. And if you start with that sort of presumption of good faith on the part of the person that you're arguing against, it helps you to have a much better and deeper understanding of what their position is. And that in turn helps you figure out what are your most effective responses to that position. Because if your response is just, oh, you're lying, you're a scoundrel, it's not going to be a very effective oral argument. Just like it's not going to be a very effective conversation that you're having with anybody else on any other issue. But if you really do understand their positions, you can start to understand why, what your best arguments are for why that position happens to be wrong.
oh yeah, good, very good advice. You've also spoken in the past about the importance of humility and advocacy. A little bit of a different point, I think, than the one you just made. But what did you mean by that, and how do you reconcile that importance of humility in your presentations before the court with passionately defending your client's interests?
Sure. I think what I mean by humility is acknowledging the possibility that you could be wrong. I think on a lot of these difficult questions, there are always going to be multiple reasonable approaches that somebody could take. And you need to acknowledge that those other approaches are reasonable and maybe you're wrong. Once you've understood that and acknowledged that, then I think it puts you in a better position to articulate why, notwithstanding that hesitation, you're actually not wrong. To me, humility though is more. It's less important in oral argument because in oral argument you do have to, at the end of the day, stand there and stand your ground and make clear that you're right. To me, humility is much more of a value that I adhere to in how I interact with my colleagues and the lawyers in my firm and my opposing counsel. I've often said that, I don't necessarily think that I'm the best writer. I don't necessarily think that I am the best oral advocate, but one thing that I've always been really good at is identifying people who were smarter than I was and then convincing them to come and work for me. That's, to me, if there's been any key to my success in this career, it's been that. Convincing really good young people to come and help me do what I do. And I think that one of the reasons I've been effective at that is because I can convey to them that I actually need them. And if they come with me, they're going to have a lot of opportunity because I need them to have a lot of opportunity in order for me to be successful.
Uh, that's a great approach. Um, Constitution Day invites us to reflect on the document's ongoing relevance. Are there parts of the Constitution that you think Americans either take for granted today or maybe are misunderstand the importance of?
So years ago, I had the opportunity to attend a Constitution Day lecture at the Marine Corps Academy I think they were hosting it out at Quantico, where Justice Scalia delivered the Constitution Day lecture. And I'll never forget it. He started the lecture out by just asking the audience of Marines, what did they think the most important part of the Constitution was? And, a hand would go up and somebody would say the First Amendment, the Second Amendment, the Fifth Amendment, the Fourth Amendment. And Justice Scalia then segued into his lecture by saying that, there are countries all across the world that have bills of rights. They're more detailed than ours. They're more protective than ours. But their bills of rights aren't worth the paper that they're written on because they don't have the structural protections that our Constitution has embedded into it, where you have three co-equal but independent branches of government that serve as checks upon one another, ultimately anchored by an independent judiciary. And I think it's that sort of, I think that most lay people don't have the appreciation that our structural constitution, appreciate as much how important our structural constitution is to the success that this country has so far had over the 250 years of our history. And so a lot of times these very difficult, big structural cases get viewed through the lens of, oh, does it help this part? Does it help this party or does it help that party? When what I think that the justices are really struggling with is how do we preserve this structure that has served the country so well for well over 2 centuries now. So if I had to point to anything, it's the structural aspects of the Constitution, the separation of powers, both across 3 branches and then vertically between the federal government and the states.
No, it's a very powerful observation, and I think Justice Scalia would be very proud of the way you described it, and it's very important for Americans to understand today. What do you think about the resilience of our Constitution? Are there elements in our constitutional form of government that give you confidence in its durability, or any aspects of it that might concern you?
It's easy in any given political moment to feel that the country has become so politicized, and I despair about that as much as anybody else. But at the end of the day, I do think that the structure that we've set up works. And I think that most importantly, you've got a robust democracy where the people can express their views at the ballot box and decide who their elected representatives are going to be. And then you've got it anchored by an independent judiciary that enforces the lines between the different branches of government and between the fundamental laws as set forth in the Bill of Rights and the statutes and executive orders that Congress and the president are passing. So even if sometimes I worry that things are devolving into a little bit too much partisan politics. I have a lot of faith that the structure that we've set up is going to hold. What's the line from the Justice Kennedy opinion? When structure fails, liberty is always in doubt. Well, so far it looks like the structure is holding to me.
Yeah, I echo those sentiments. We're going to take some questions from the audience here in a moment, but I, uh, I, you may have already just articulated this, but I was going to ask you if you were speaking to high school students today, a civics class today, how would you explain why the Constitution still matters?
I would have given the exact same answer that I gave. I would have referred to Justice Scalia's Constitution Day speech before the Marine Corps that one day, and how the structure of our Constitution is so important. It's what ultimately protects all of our rights. You know, at the time of the founding, the big debate between the Federalists and Anti-Federalists was whether you even needed a Bill of Rights, with one side saying you don't need a Bill of Rights because, you know, the Constitution doesn't give Congress the power to do the things that you're worried about. None of this list of enumerated powers gives them the ability to infringe on free speech. So why are you worried about a First Amendment? The other side said, well, yeah, maybe that's right, but, you know, we're just not so sure. So we'd like to have a Bill of Rights to make clear what the limits on Congress's power were. I think just the fact that they were having the debate underscores the fundamental importance of the structure of our system of government.
No, your description of it and Justice Scalia's comments bring to my mind. You may know, in years past, I was a CEO at the museum here in Washington, and we had there was a museum dedicated to educating the public about our constitutional First Amendment rights. And we had a visitor from Russia, and he walked through and soaked it all in, all of our exhibits. And at the end of his tour, he looked at us and he said, you know, we have a Bill of Rights and we have freedom of speech in Russia too. I said, but the difference in America is you're free after you speak. Which is a great line, and the reason is quite exactly what you've described. The reason is what you've described is we have an independent judiciary that enforces those liberties and rights, and you can go to court and you know, argue your case that the government has breached those rights. So. I want to pull up some questions here in a moment. Noel, one other question I'll ask you is if you have any other stories or insights about the Constitution that, thank you, that may be less known that you would like to share with us today.
I'll give you one story that I think has had a big impact on the Constitution, and it's my favorite story from my days as a young law clerk for Justice Scalia. There was, you know, back in those days, if Justice Scalia were writing the majority opinion, the law clerks would often do a first draft for him, and then he would sort of, you know, weave that into his own magic. But when he was in dissent, he usually just wrote the first draft of the dissent, and he would share it with us so that we could, you know, help with filling in citations and the like. There was one case, wasn't a particularly important case, but he was in dissent. And so he gave the law clerks a copy of his dissenting opinion. And we all looked at it, and it was classic Scalia rhetoric. You know, it was funny, it was biting, it was sarcastic. But we went to him and we said, Justice, you know, there are a couple of other justices who are also dissenting, and we think that if you tone down the rhetoric a little bit, they'll probably join in your dissent. And he looked at us and said, you know, that's a good idea. Let me think about that. Went back into his chambers, worked on the opinion for a few more hours, came out and gave us a new draft. And as we reviewed it, we realized that, you know, much to our surprise, he had actually jacked up the rhetoric. So we went to him again with the same pitch about how, you know, there were a couple of other justices dissenting, and if he toned it down, we thought that they'd join the opinion. And, you know, he looked at us and at the opinion and at us, and then he said, in words that I'll never forget, he said to us, you know, sometimes I just got to be me. And over the years, I've sort of reflected as to what Justice Scalia was getting at. I think that what he was getting at was that he knew he had lost that case on that day, and he was not going to be able to convince a majority of his colleagues that he was right. And so he wasn't really trying anymore. That wasn't the scope of the exercise. Instead, he was now engaged in a different debate. It was a debate across time where he was trying to convince future lawyers, future law students, future judges that his view of the law was the right view of the law. And he wasn't willing to water down the clarity of his rhetoric if it was going to get in the way of him having that debate across time. And if you look at where the court is today, I think that, not 100%, but by and large, Justice Scalia has won that debate across time. And what you often see amongst the six or more conservative justices, and frankly, I think I would probably throw Justice Kagan into that mix too to get to seven, is often a debate over how to properly apply the principles that Justice Scalia was at the forefront of articulating when he was a younger justice on the Supreme Court.
Well, thank you for those observations. No, I'm going to turn to some questions from the audience. A couple here we have time for yet. And one is the Solicitor General is required to be, quote, learned in the law by the statute creating it. How does that impact the way the SG's office works?
Yeah, it's interesting. It's the one of the few provisions in the statute that it essentially creates a job qualification for one of the attorneys in the Department of Justice. I think back when I was in the Office of Legal Counsel at the Department of Justice, I heard somebody once suggest that they thought that was unconstitutional because you can't constrain the president's appointment power by requiring that they appoint somebody who is learned in the law to a particular position. Look, in all honesty, I can't claim that that phrase has had that much of an impact. I think that almost by definition, the people who are being considered for that position are going to meet the qualification of being learned in the law. It is kind of a nice thing to be able to say, look, by statute, I am learned in the law. But frankly, I think that all of the lawyers at the Department of Justice, both the career lawyers and the political appointees, would meet that standard.
Well, and the experience itself certainly increases knowledge as you go on a daily basis there, I'm sure. Another question, how often should the SG volunteer to a confessed error, and what policies help determine those?
Sure. That happens very rarely. Typically it arises in the context of a criminal case where the government actually procures a criminal conviction. And then when it's moving up the chain, the Solicitor General would make the decision that actually one of the objections that the criminal defendant raised was valid, should have resulted in a reversal of the conviction, and we're going to concede that kind of error. I have to say, I can't recall any instance where I saw that. Maybe there were one or two instances where I saw that, but it's very rare that you're in a position of having to say we made a reversal prejudicial error in the court below, and therefore the decision should come out the opposite of what we actually procured.
Mm-hmm.
Now that's different from when you just reverse legal positions. There are times where where the office will change its legal position. I think that's a little bit different than confessing error. What you're just saying is that the legal issue, the position that was previously being taken, we no longer adhere to, and that may result in the same effect in some cases, where you're coming in and saying you should rule against us. So in that sense, maybe that type of thing happens slightly more often, but neither of them happens very often at all.
Okay. One last question. How can citizens and young students better understand and engage with the Constitution today?
I'll give you the advice that Justice Scalia gave to all of those Marines on that day many years ago. He pulled out his copy of the Federalist Papers and he said, every single one of you should have a copy of this and read it. It explains the foundation of our country.
Very good advice, and it's perfect advice to end our discussion today on Noel. We're so grateful that you spent time out of your day on this Constitution Day to be with us, and it's very educational and we hope inspirational to others to go into
Do it, John.
the practice. And I'm sure we could have gone on for another hour. We're good friends, but we are right up on the hour. And I want to thank you very much again, and to let our audience know that a video of today's conversation and previous virtual programs from the Supreme Court Historical Society can be found on the Society's YouTube page. And a link is in the chat on this program. So thank you again, Noel, for joining us, and thank you all for observing. We wish you a happy Constitution Day.
Thank you.